Lastly, we have Sharon Stevenson arguing for the state of Colorado.
Mr. Chief Justice, and may it please the Court. Throughout its history, this Court has recognized that state power is at its apex when it regulates to ensure safety in the healthcare professions. Colorado's law lies at the bullseye center of this protection because it prohibits licensed professionals from performing one specific treatment because that treatment does not work and carries great risk of harm.
Now, Ms. Stevenson has a point. The power to regulate healthcare professionals lies with the states and not the federal government. However, for her argument to be valid, she will have to show that this treatment includes the risk of actual harm.
No court has ever held that a law like this implicates the First Amendment, and for good reason.
I don't know whether courts have upheld this or not, but I've already shown that this law cannot implicate the First Amendment, only not for the reasons Ms. Stevenson will use in her argument.
First, the law applies only to treatments. That is, only when a licensed professional is delivering clinical care to an individual patient. In that setting, providers have a duty to act in their patient's best interest and according to their professional standards. The First Amendment affords no exception.
Who decides what is in a patient's best interest? Does the state, with all the political baggage that comes along with it, really believe their view of what's best supersedes everyone else's? Apparently so.
Second, because this law governs only treatments, it does not interfere with any First Amendment interest. It does not stop a professional from expressing any viewpoint about that treatment to their patient or to anyone else. And because Colorado's law regulates treatments only, and because it enforces the professional standard of care, the law falls squarely into the reasonable regulation of professional conduct that does not trigger First Amendment scrutiny.
We'll encounter this phrase, standard of care, a lot in this case. What is standard of care? Well, from NIH's National Library of Medicine, we read, the standard of care is a legal term, not a medical one. Basically, it refers to the degree of care a prudent and reasonable person would exercise under the circumstances. State legislatures, administrative agencies, and courts define the legal degree of care required. So the exact legal standard varies by state. So the phrase standard of care is not a medical term, but a legal one, a term established by state government, which means Ms. Stevenson's argument boils down to the Colorado law is meant to enforce the standard of care by establishing it as the standard of care. Circular logic, anyone?
Petitioner's argument, on the other hand, cannot be reconciled with history, precedent, or common sense. A state cannot lose its power to regulate the very professionals that it licenses just because they are using words.
Ms. Stevenson is right. However, the Constitution of the United States does put limitations on states' power to regulate professionals, just not in the First Amendment.
A healthcare provider cannot be free to violate the standard of care just because they are using words. And a state cannot be required to let its vulnerable young people waste their time and money on an ineffective, harmful treatment just because that treatment is delivered through words.
Ms. Stevenson seems to imply that the standard of care is a medical standard, but as I've shown, it's not. This is the state prohibiting treatment that it believes ineffective and harmful without showing real proof.
Petitioner asked you to enjoin a bipartisan law passed by 25 different states, but she did not put one single piece of evidence into the record. Not a single expert, not a single study, not a single mental health professional willing to endorse conversion therapy. And there is a mountain of evidence to the contrary.
So Colorado wants the Supreme Court to deny the preliminary injunction against the law. Why am I reminded of something most mothers have said? If all of your friends jumped off a bridge, would you follow them? Because Ms. Stevenson seems to imply that Colorado should be able to enforce this law because other states have similar laws. Does that mean those laws are legal?
On this record, we request that you affirm the denial of preliminary injunction. I welcome your questions.